Ladies and gentlemen, good afternoon. My name is Cristina Volpin, and it is my pleasure to facilitate the discussion this afternoon on a very novel and exciting topic, competition in labor markets. The topic is indeed still very new, and at this very moment, some of you in the room are probably asking yourself what competition has to do with labor markets, and if employment and the level of wages are outside the sphere of competition. What is the role the competition authorities can play in these markets? I would like to answer this question by referring to Professor Carl Shapiro's intervention in a roundtable we held on this topic here at the OECD last June, where he stressed the importance of well-functioning labor markets, and when he made the point that in the same way in which if we have monopoly power, we may be concerned with high prices for consumers. If we have significant market power on the employer side, we may be concerned about low wages for workers. And I quote, the economics is very similar. So the debate and the discussion about competition enforcement in labor markets has attracted more and more interest in the last few years. One of the reasons for this interest, for why this discussion has recently become more important, is its potential link with some of the indicators of inequality, such as the level of wages and the labor share of income. And another reason why this discussion has become more important is that recent studies conducted in the US and in other OECD countries suggest that there is a high level of concentration on the employer side in certain markets. And a negative correlation between this high level of concentration and the level of wages, which is interpreted by some as to indicate that the holding of large market shares in the hands of few employers may be linked to a decrease in the level of wages paid to workers. The wider public policy debate, combined with this recent research on the topic, naturally focused the attention on the role the competition authorities could play in these markets. Central to the discussion is the notion of monopsony in labor markets, as we will hear from our speakers today, which is broadly defined as a situation when one or few employers have such market power that allows them to decrease the level of wages or worsen working conditions below competitive levels. When we are talking about labor markets, however, we are not only talking about prices and quantities and quality, like in other input markets, but we are also talking about the livelihood of people, because their work is perishable, and about their preferences, which make markets thinner, and about the risks involving changing jobs, which due to matching difficulties and switching costs. It may be intuitive, but it is worthwhile stressing that in labor markets, for a hire to occur, both the buyer of labor and the seller of labor must find, like, and choose each other. Due to this double differentiation, the matching between workers and employers is generally a bit more complicated than in traditional transaction between a producer and a consumer. In his seminal book on imperfect competition in labor markets, Monopsony in Motion, Professor Alan Manning memorably remarked, people go to the pub to celebrate when they get a job, and they go to the pub to drown their sorrows when they lose their job, rather than picking up another one straight away. Now, besides stressing the centrality of pubs in our lives, which the OECD does not encourage, this quote teaches us that there is indeed something different about labor markets, which Professor Alan Manning identified as lack of information, heterogeneous preferences of workers, and mobility costs. The existence and the widespread use of non-compete agreements may also further reduce the responsiveness of workers to a decrease in the level of wages or to the worsening of working conditions. All these factors may magnify employers' market power, or in some cases contribute to monopsony power. And whilst competition authorities cannot address all of these issues, they certainly can play a fundamental role when employers artificially create, maintain, or increase their monopsony power and exploit it in an anti-competitive way. So far, however, competition enforcement in labor markets has been extremely limited. Some competition agencies have recently started to take a closer look at labor markets across various jurisdictions, such as in the US, but also in Japan, in Hong Kong, and more recently in the EU in the context of the protection of platform workers. But competition authorities face significant theoretical and practical challenges when they analyze monopsony power, particularly in relation to enforcement. One fundamental challenge is analyzing these practices under the consumer welfare standard, as it is traditionally interpreted. In other words, the question arises whether labor market harm is sufficient to justify enforcement, or whether consumers downstream at the level of the product market also need to be harmed and prove to be harmed. But challenges also arise on the more practical level. How do we define labor input market, and how do we correctly determine substitutability between jobs? And how do we measure the negative impact of a transaction? And finally, is competition law the best tool to address employers' monopsony power, or would regulation be a better way to address some of these issues? So these are all fundamental questions that will be discussed by our speakers today. We are very fortunate to have an excellent panel with us that I will now introduce in the order of their initial remarks. So we will start with Eric Posner, who is a professor of law at the University of Chicago and author of many articles and books, including the very well-known Radical Market. Eric is also working on a book on this subject with the intriguing title of How Antitrust Failed Workers. And I think it is safe to say that this title reveals a bit where Eric stands on this debate. Next is going to be Andrea Bassanini, who is one of our leading labor economists working in the Employment, Labor and Social Affairs Directorate here at the OECD. Andrea is author of a number of publications and also editor of the recent OECD Employment Outlook dealing with monopsony power and vulnerable workers. Next, Nancy Rose, who is professor and head of the Department of Economics at MIT and previously served as Deputy Assistant Attorney General at the US Department of Justice. There, Nancy worked on cases where labor market harm was considered, as well as on the antitrust guidance for human resource professionals. And finally, we have Tommaso Valletti, who is professor and head of the Department of Economics and Public Policy at the Imperial College Business School and former chief economist at the European Commission DG Comp. Tommaso also has a number of publications, including seminar articles on buyer power, which is very much at the heart of today's discussion. So now each of the panel members will frame the discussion with initial remarks of about 10 minutes, excuse me. We will then have some follow-up remarks, and then we will open the floor to questions. So start thinking about the question you would like to ask to our speakers. We start with Eric. So Eric, if you would like to kickstart the discussion by telling us about the nature of labor and how do you see the competition legal framework apply to these markets?
Okay, thank you, Cristina. To get your intuitions going, let me give you a hypothetical example. Imagine two national retail chains, and they want to merge. They go to the competition authority for approval. And in fact, this happened a few years ago in the US involving two drugstore chains, Walgreens and Rite Aid. And so, as you know, what typically happens, the competition authority will look at the possible effects on product market competition. So if you think of two drugstores merging, or two drugstore chains merging, the result will be that in particular neighborhoods, the two drugstores will become one drugstore. And the competition authority will look at the likely effect on prices for consumers. That we all understand. But what about the following effect of this merger? If in a particular neighborhood or area, two of, let's say, 3 or 4 drugstores merge, the labor market will be affected. So maybe in the past there were 3 or 4 employers of pharmacists, and now there's one fewer employer of pharmacists. Wouldn't that have an effect on the market for pharmacists? And the answer is very likely that it would. Just as in the product market side, on the labor market, if you have fewer entities buying people's labor, then you would expect wages to decline and possibly for the labor market to become less efficient. And so also production would decline as well. Now, it turns out that, as far as I've been able to tell, in the United States and I believe in Europe as well, competition authority has never, not even once, looked at the labor market effects of a merger. And this should be very surprising. I think it's surprising from an economic standpoint, since we should be concerned as much about labor markets as product markets. The consumers under the consumer welfare standard are, after all, people who work. And if their salaries are depressed because of concentrated labor markets, they'll have less money to spend in the competitive product markets where prices are so cheap. So why is it that, labor markets are neglected in competition law? So I can speak a little bit about the United States. When the Sherman Act was passed in 1890, it was understood at the time that the statute would incorporate the common law restraint of trade into federal law, the common law notion of a restraint of trade. So even when in the 19th century the common law was relatively laissez-faire, courts would refuse to enforce restraints of trade. And one such restraint of trade was the covenant not to compete, where an employer and a worker agree that if the worker leaves employment, he or she cannot work for a competitor of the employer for a certain period of time. Those were regarded as restraints of trade and were scrutinized under the common law. And so this common law focus on labor markets as well as product markets would have been incorporated into federal antitrust law. And there have been a number of labor side antitrust cases in the United States, but very few. And I've actually counted them up. There have been thousands or even tens of thousands of antitrust cases involving product markets. There have been perhaps a few dozen or maybe 100 involving labor markets. Most of those cases involve sports leagues. So in a sports league, the independent entities, the teams, normally agree to certain rules. And there are some good reasons to restrict the ability of teams to take each other's players. But there are also anti-competitive reasons for doing that, and so courts have reviewed challenges to the rules in sports leagues and have sometimes struck them down on competition-related grounds. But other than that, there's been almost nothing. Almost nothing. A few challenges here and there, and the challenges that have occurred have been almost uniformly unsuccessful. Now, this changed about 10 years ago. In 2010, the Justice Department conducted an investigation of the Silicon Valley tech firms, including Google and Apple and eBay, and discovered that they had entered into a no-poaching agreement. So Steve Jobs of iPhone fame had actually orchestrated this agreement. The tech companies agreed not to steal away each other's software engineers. Now, if this had happened on the product side, there would have been a criminal investigation, and Jobs would have ended up in jail. I think the government didn't feel like it could do that because there hadn't been much government enforcement of antitrust law against employers. The tech companies did settle with the Justice Department, settled a civil claim, and they were subsequently sued by their workers and settled with them as well. This was very striking. One got the sense, looking back at this, that it didn't occur to the CEOs of this company that they were doing anything wrong, despite the fact that they had enormous legal resources. Okay, a few years later in the United States, there was another scandal. This time, it was at the other end of the market. It involved a sandwich chain called Jimmy John's. Jimmy John's runs these little sandwich shops all around the country. And it turns out that Jimmy John's had put non-compete agreements in the contracts of virtually every worker. These were people who built sandwiches. They didn't have trade secrets, maybe the recipe of the mayonnaise, but not much. And they didn't have elaborate training. Now, the public was actually quite outraged by this because just as an intuitive matter, it seemed quite unfair that people who were just making sandwiches for this company would be unable to go work for another sandwich chain. And because of the way the non-compete was drafted, this would be true for basically all of the United States because it was something like within 6 miles of a Jimmy John's, but since there are thousands of Jimmy John's spread across the United States, the workers would not be able to get jobs anywhere. And apparently, the bosses might have used this non-compete as a threat. If you leave, you can't go work for another sandwich chain, like any kind of sandwich chain or retail food franchise. Okay, so what to make of this? It seems like anti-competitive practices among employers is actually quite common. And this view was supplemented by recent research by 2 economists at Princeton, which showed that the largest franchises in the country, including McDonald's and Burger King's and companies like that, used no-poach clauses in their franchise agreements, which meant that if you worked for a McDonald's franchise in Chicago, let's say, and you quit to go work for another McDonald's franchise in Chicago or in another city, you would be prohibited from doing that. And this, too, this behavior was also challenged, this time by the states, and most of the franchise companies dropped this clause. Okay, so this is where, this is the legal side of the story. Not much went on for more than a century, although it was well understood by the courts that the American antitrust laws apply to labor markets. Then in the last 10 years, things begin to change. Okay, now I want to tell a little bit of the intellectual history here. I'm going to defer to the economists for the most part, but I want to explain why there's so much interest now in this area of intersection between competition law and labor markets. Over the last few years, a number of economists have written papers that have documented the extent of labor market concentration in the United States. Now, labor market concentration means quite narrowly a relatively small number of employers in a particular labor market. Of course, there are hundreds of thousands of labor markets. They're defined by area, the area in which people consume, in which people commute, by the type of job, accountant or sandwich maker or lawyer. It turns out that most labor markets in the United States are highly concentrated, much more highly concentrated than the levels at which the Justice Department in the United States would normally be concerned. Labor markets are in the United States are much more concentrated than product markets are. Now, these economists also argue that there is a negative correlation between labor market concentration and wages. That view has been contested by some people, but that's not what I want to stress here. I just want to point out that on the one hand, we have an enormous amount of product side antitrust litigation and almost no labor side antitrust litigation. And yet, labor markets are far more concentrated than product markets are. So these facts have gotten the attention of government officials in the United States and policymakers of various sorts, private lawyers who are increasingly bringing labor side antitrust cases. And the reason, now there are a lot of reasons for this, many of them mentioned by Cristina. People are, of course, worried about growing inequality and wage stagnation. I'm not making the claim that there's necessarily or a proven connection between labor market concentration and these other phenomena, but they certainly seem related and worth further investigation. And so with that, I will move on to the next panelist.
Okay, thank you very much. Andrea, what's the perspective of the labor economist on the evidence of employers' monopsony power?
Okay, thank you so much. I almost feel intimidated to speaking to such so more important people, more prominent people than more prominent people than I am. Okay, let me try to distinguish, if I can, and probably won't be very well, the different perspective that labor economists can have with respect to what we just heard, for example. So I guess when you look at monopsony from the point of view of competition policy, what you are interested is on actionable situation. So where you can identify in precise markets that there is some harm and you want to, and there is probably some violation of some antitrust behavior, and so you want to intervene in that market in a way that you have clearly identified. I guess from the point of view of the labor markets, we have, let's say, a kind of a more aggregate approach, in a sense. It's not so much that the technologies is different, but I mean, what we are interested in the question we ask is that, do we observe a pervasiveness of monopsony, meaning with monopsony, as Cristina said, a situation where employers have sufficient market power so they can inefficiently depress labor demand in such a way that they reduce wages and they get less costly working conditions. Now, typically what labor economists look at? So the first thing they look at is what is called the residual labor supply elasticity that has been estimated for years and years in different types of markets. And what we look sometimes is some kind of, let's say, survey or meta-analysis of these type of estimates, try to get some idea whether we have a pervasiveness of the issue or not. And for example, recently there was let me explain what is the residual labor supply elasticity. Is the capacity of workers of switching employers in the case of an idiosyncratic reduction of the wage just in that employer. So ideally, if the labor market is perfectly competitive, I expect that if my employer reduces my wage and there are other firms offering a better wage or the same wage that I had before, I would move. In practice, this doesn't happen. So if that happened, we should observe infinite residual labor supply elasticities. In practice, what a recent meta-analysis of Anna Sokolova and Todd Sorensen show, using a large number of elasticities in the literature and taking into account for a number of observables, so characterizing these different studies, including the quality and the rigorousness of the publication, is that typically these labor supply elasticities are below 10. So they are one-digit number that typically is an indication of a very relatively high monopsony power. So not to say that all markets are monopolistic, but there is some monopsony in many markets. So this is a kind of macroeconomic phenomenon. Interesting, and perhaps this linked to what Eric was saying before, the estimates tend to be lower in the United States than in Europe. And this may have to do, but this is just a guess, with the fact that in Europe there is much more collective bargaining, and collective bargaining can act as a countervailing seller power, in this case, with respect to the employer. Now, just to add a couple of things from our point of view, which for us what is interesting is what is actionable from the labor market side. So the issue is why do we observe this monopsony power? Now, one of the issues is the difficulty in the mobility of workers. So any policy that would help labor mobility would be an interesting instrument for us. A second issue is the issue that we observe that markets could be naturally concentrated for different reasons. So I wouldn't go into the evidence that Eric told us. Perhaps one thing to notice that this is not just an issue of the United States. We observe with the same techniques, we observe that at least in other 6 OECD countries, similar levels of concentrations in the labor market. Now, what is of interest for us is also that employers can engage into active behavior to increase their market power, and this behavior could be completely legal in a sense. Eric cited the case of Jimmy Jones, so of the use of non-compete clauses in a way which is clearly abusive. Now, it's interesting that in that case, you probably can make an antitrust case to say that, or anyway, a common law case even, that there was no justification for that clause. But in general, we observe that in the countries where we have data, that there is a lot of use of non-compete clauses, even in, with workers that, for example, have no education. So it's hard to say that they have access to trade secrets, or that there was some protectable interest that justify the clause. For example, a recent survey in the Netherlands showed that 11% of people without a secondary school diploma are covered by a non-compete clause. And this number corresponds more or less to the numbers that we find also for the US. Now, it's interesting and it's important to think about these things because even from the labor economist perspective, until 10 years ago, nobody would believe that non-compete covenants were an instrument covering beyond specialized professionals that were really had knowledge of trade secrets. So at the end, we need much more data, and unfortunately, the data are available only for very, very few countries and often very patchy. Now, in that, I would like to cite and terminate very quickly another statistics for the United States, which is a recent survey by Colvin and Chirolds, showing that 32% of plants with more than 100 workers, in these plants, all workers, by declaration of their employers, are covered by non-compete covenants. It's very hard to think that these are only used to protect legitimate interest. Now, indeed, when we look at the few recent studies on the economic effects of non-competes, what appears to be the case is that the only clearly detectable effect is that they reduce job mobility and they reduce wages. All the other effects, except, just to be precise, except in very specific markets where workers are paid through profit-sharing schemes. In that case, they increase wages. But it's only a very specific market that covers, for example, CEOs or, in certain cases, physicians. All the other effects, the evidence remains much less clear. And I think I can close here.
Thank you very much, Andrea. Nancy, would you like to give your view on the evidence on monopsony, and more importantly, whether you think it supports the need for more enforcement?
Sure. Thank you. So I think it's terrific that we're getting more attention to the issue of labor market harm. I would also say what we shouldn't lose track of while we're focused on workers is that upstream harm in general, that is, anti-competitive behavior by purchasers, is something that I think competition enforcers have probably not spent as much time thinking about and acting on as would be warranted. And certainly there remains a lot of scope for academics to work more on it. So as Eric mentioned, enforcement in labor markets against anti-competitive behavior in labor markets is relatively rare as compared to product markets. I would say it's, I think, not as novel as many of us might think when we first start thinking about this question, but certainly not as frequent as appropriate. And the no-poach example was interesting. So I was, as Cristina mentioned, involved in the DOJ when we issued the labor market guidance, which was, you could think of it as essentially putting industry on notice to say that if you were colluding in labor markets, the agencies would investigate and prosecute as appropriate that behavior criminally, not just civilly. So there had been civil cases before, no poach was an example. I think the agencies were reluctant to go after executives with arguing for prison terms, in part because there hadn't been a previous criminal case. Although I would take some issue with Eric saying the reason was executives didn't understand it was wrong. There's a New York Times interview with Edward Colligan, who was the CEO of Palm, who was one of the CEOs Steve Jobs approached to say, you know, hey, let's agree not to poach each other's employees. And Colligan at the time said that he told Jobs this was not only unfair to employees, but probably illegal. So I think there was perhaps more awareness than some of the behavior would have indicated. I think people... right, but I think part of the problem was, I mean, he didn't agree. We haven't always prosecuted even in the product markets, right? Think of Bob Crandall calling up Howard Putnam in the airlines example and saying we should collude, and he didn't go to jail either. So it's not just labor. But I think part of what the HR guidance was intended to do was to say, yes, there may have been a lot of civil prosecutions of this kind of what should be per se illegal criminal behavior. That door has closed. And so, again, the investigations would begin criminally. It wouldn't necessarily mean criminal charges would be brought in all cases. So I want to step back and think about what the literature tells us and what we can learn and sort of where that points us. And I would start by saying that I have very significant doubts that the wage concentration literature that Eric mentioned has much actionable guidance for antitrust enforcers. I think there are problems with that literature in terms of drawing conclusions about whether the lower wages are actually reflecting reduced competition for workers or not. And I think at that level of aggregation, there's just not a lot that we can take away from that for enforcement. But I think that it's important not to stop with that, because what a number of economists, particularly, I'll single out two papers that I think are really beautiful in this space, have begun to do is say to look at competition-induced reduction in labor market competition. So that is, in particular, there's a paper by Prager and Schmidt that looks at US hospital mergers, and they find that the highest concentration mergers lead to reductions in wages or wage growth for healthcare specific workers, so not all workers at those hospitals, but on the order of 4 to 7%, so quite significant effects. Interestingly, when I say that they find that for the highest concentration mergers, these are levels that are well beyond product market challenges. So the average HHI in those in the mergers that cause these harms is 4,000. The delta HHI is over 1,000, so we're talking about very highly concentrated markets with even higher concentrations of post-merger in the product market. We'll come back in a moment and say, well, why did those mergers get through on the product market, let alone their labor market side? There's a Princeton PhD student, David Arnold, who's on the market this year finishing up his PhD, with a paper that looks at local labor market effects of mergers using US establishment and employment match data for a very large number of mergers in the US across local labor markets. And in particular, using mergers that affect multiple labor markets or multiple local geographies. And so he can look at what the effect of a particular merger is in a market where it has a big effect on labor markets versus one where it has a much smaller effect. I think the other thing to note about this paper is it's beginning to use, I think, something that gets us closer to the way competition enforcers think about markets, which is he's looking at flows of workers from the merging firms. Where do they typically go, or where are they pulling workers from? So something closer to the type of diversion analysis that we do in product markets, which I think is a huge advance, because so far a lot of the studies, in particular these wage concentration studies that I mentioned, are using pretty arbitrary definitions of labor markets that almost certainly aren't correct. What he finds, again, is not much of an effect of these mergers if there's not either an initially high level of concentration and or the merger doesn't have a big effect in increasing it. But he finds in the 5% most concentrating mergers that there are average wage declines of about 3.5%. So again, something that we ought to be able to pick up and measure, and something that we ought to worry about. So what do I take away from this? First, that competition policy could matter for workers. That's not surprising, but it is important validation. Secondly, that many of the significant merger impacts have probably been picked up in product market investigations. So the hospitals example is a great one. Why did we observe those mergers? Well, they were mergers that were too small to be notified typically to the Federal Trade Commission, which is responsible for hospital mergers in the US, or that were challenged, but the courts did not uphold the agency's challenge. And so they were mergers that got through not because we ignored labor market effects, but because we weren't able to enforce the product market harm. I think Eric's drugstore example is another good one where, probably if you've got drugstores closely co-located enough that it matters for workers, there's probably a product market problem as well. And so we may not be missing to a first degree if the wage effects are for industry-specific skills associated with those sectors. Product markets might do a pretty good job, but not always. So where won't it be the case? Well, if there's a local labor market, but a national or global product market, then the agencies may look at product market competition and say, no problem from this merger, unless you look at the local labor market harm. When the firms aren't direct product market competitors but do compete in labor markets, our product market approach to mergers is not going to work. So something like the Silicon Valley no-poach case tells us those firms were across a wide variety of different product markets. They weren't competing for customers. And if that's all we looked at, if two of them chose to merge, again, we might miss the labor market effect. And then I think there are probably a set of mergers where maybe we're close on the product market side, and we may decide either due to prosecutorial discretion or it doesn't quite meet the structural presumptions that we're looking for, that maybe the merger's not worth blocking, or we'll accept some modest divestitures. And again, if we haven't looked at labor markets, we may be missing some of the harms. I think that points not only to the need to think about whether there are classes of workers that are likely to be affected by the merger and how that would change our merger analysis and our merger investigation, but also to think much more carefully about remedies, because we tend to allow often, if we've got a merger, of companies that may have hundreds of products, we may narrow down to just a handful of products in the investigation, and then we might allow piecemeal divestitures that would, say, spin off a subset of those products or a subset of those divisions. So I'll take, in my closing remarks, the Wabtec-Favely merger of rail equipment manufacturers that was investigated both in the European Commission, by the European Commission and the US. The European Commission settled that merger investigation with a divestiture of the sintered friction materials division. The US settled it with a divestiture of rail freight car brakes and a master control valve for freight car brakes divestiture. Why do I raise this? Because the DOJ subsequently announced, but arising in part out of the merger investigation, took action against Wabtec, Favely, and Knorr for their no-poach agreements on employees that, quote, affected multiple jurisdictions and multiple business units. So the companies, by agreeing not to poach each other's employees across these many business divisions and geographic areas, told us that they viewed each other as important labor market competitors. And yet the divestitures dealt with a very narrow set of product categories. And we may well have left skilled employees in those sectors exposed to reduced competition from that merger. I mention that because there are further mergers that are happening in, broadly speaking, this kind of rail equipment market. And maybe this would be a good time for the agencies to look at what labor market effects might be.
Thank you, Nancy. Tommaso, thanks for waiting. Can you tell us whether you agree with Nancy on this idea that we need to be a bit cautious on the pervasiveness, on the studies on the pervasiveness of monopsony power, and also a little bit more about the economics of monopsony, and whether you think there should be more room for enforcement in the EU?
Thank you very much, and good afternoon to everybody. Thanks for having me on this panel. First, a disclaimer, doesn't apply particularly to this panel, but I think it's important in policy circles like this one to say whether or not we're working for any company. So currently, I am in academia, I'm not doing consulting work, and my research is not funded by any company. This should be a standard that everybody should try to do in this public fora. The second point, or the first point, really, that I want to make is it may be useful for this audience to tell you a little bit about the analogies and the differences between monopoly and monopsony, oligopoly and oligopsony. So in a sense, in theory, there are two sides of the same coin. They are both about frictions. So when you think about product markets, when you're buying something, surely the price is important, but there are also non-price elements that will drive your choice. If the price, we're in Paris, of a baguette declines by a cent, you're not going to go to the other side of the town to buy your baguette, right? There is transportation cost, there is product differentiation, there's lots of characteristics, there's asymmetric information, you may not really know about the quality of this other baguette. And so you don't act only on price. So there are frictions, and this friction will give some market power to the bakery, in this example, to your local bakery. Similarly, in the labor market, the wage is important, but there are also non-wage aspects. So the hours, the flexibility, the social environment at work, the commuting time, the distance, all these are factors which are non-wage specific that generate frictions, and these frictions, again, give some market power, in this case, to the firm that can employ that kind of person. So these are it's the analog. In a monopoly, you would have a firm that will trade off selling a bit less with making a higher margin. Okay? That's a trade-off that the monopoly makes. And in a labor market, the monopsony will do the same. Will try to sell a bit less by employing less people in order to have a higher margin by having cheaper wages. Okay? So this is very, very obvious to us in some sense, and that's the analogy that we understand from the economics, but that's also where, in practice, lots of the analogies actually stop. Okay, when it comes to practical application. These are two fields of applications which are rather disconnected, labor economics and industrial organization. So we know of each other, we even have friends, but we don't use the same tools. Labor economists are a bit more advanced when it comes to labor, I mean, you would hope. So Cristina mentioned the book of Alan Manning, which is almost 20 years old. Actually, the seminal work was of David Card and Alan Kruger 30 years ago. They have different kind of questions in mind, the impact of minimum wages. But labor economists have been working with oligopsonistic models in labor markets for 3 decades. Okay? IO hasn't done that, to be honest. Okay? To be honest, and especially when it comes to practical applications, we don't do that. So what we do in industrial organization, we employ a set of models. We have our toy models, our workhorse models. Our workhorse models, when it comes to inputs, we don't call it labor. We don't even give an identity. It's an input. And when it comes to an input, we either have models, we have an infinite supply of that input at a certain price. So most likely that implies that we believe there are efficiencies in those markets. We don't care. Okay? The input is available, infinitely available at a certain wage, in this case. Or we have a set of models that are models of bargaining power, where in the applications that we use in vertical mergers, for instance, we have employed a few of those. In those applications, we have a 2-stage setting, where first there's a buyer and a seller who negotiate the bargain over an input price, a wage in this example, and then after the wage has been set, the downstream, the producer will be selling. These models can only generate efficiencies for final users. They have a built-in efficiency, so a positive impact for consumers. In case the wage is lower, then consumers will be better off, okay? But these are not the only model you can come up with, okay? These are models that we have chosen by accident or intentionally, I don't know, to have in our toolbox when it comes to competition policy. We don't, to be honest, again, there are a few examples, you can always have, but by and large, we don't use models with oligopsonistic features with an inelastic supply of the input. We don't, okay? And so it's important also to these are assumptions which are not just technical assumptions. This is not just technocratic jargon. These are assumptions which have specific meanings when it comes to the possible outcomes that you can do, for instance, in a merger simulation analysis. Okay? So it is important that there are consequences, even with ideological significance in terms of the models we use. So in principle, we could, and I'm sure the examples that Nancy mentioned, but again, it's important not to start with exceptions, right? And we have to start with the common practice, and the common practice is not to employ those models. And I want to be very frank. And maybe I want to also be critical to my own profession. So related to this, when it comes to practical applications, and this is where I start diverging a little bit from Nancy. I do hear from practitioners when I was at the Commission, well, why should we care? In Europe, we have a very strict consumer surplus standard, consumer welfare standard, fair enough. So as long as we fix any problem that we have in the final market, in product markets, we should be fine. Okay? We should be fine. Maybe it's a matter for a different intervention, for a different kind of law. I understand, I'm with you, labor is a special input, we're talking about human beings, but it's not a matter for competition authorities. This type of argument is too quick, is too superficial. I'm going to give you just an example, or maybe two, just to clarify. Take a situation with no market power. A regulated monopolist in a town. The price is regulated, okay? The price doesn't change. It doesn't change. There cannot be market power because it's regulated. It's the only bus company in a town, say. But it's also the only potential buyer of bus services. They can employ, they're the only employer. You can only be a bus driver in this town. Of course, I'm cooking up an example just for the sake of it. So, these monopsonists, because it is a monopsonist, it's the only buyer, what this firm will do, it cannot control the fare of buses is constant, will still exercise, it is a quintessential monopsony example, so we'll hire a few drivers in order to drive the wage down. That's what a monopolist does, okay? And so there will be higher profits for this guy. So what will happen to final consumers is that there will be fewer buses in towns. The price is still regulated if you're happy to find a bus, okay? There will be queues, there will be rationing, and the consumer surplus goes down. So I've just given you an example, okay? It's an example, but just an example where there is no downstream market power, pure regulation, the price doesn't change, yet there is consumer detriment. And this I can elaborate even more. In general, the point is that monopsony or oligopsony and oligopoly, they go hand in hand. If in an oligopoly and there is a further concentration after a merger, you have some reasons for restricting output because you want to have a higher price. If you combine it, they're complementary, you have even a further motivation for reducing output because it will also be driving wages down. So if a competition authority does as follows, we have a horizontal merger. That's what a competition authority does. Let's look at the product overlaps. These two merging parties, they have product overlaps. I'm going to fix this product overlap, okay? By how? For instance, by asking a divestiture, and someone else, a new player, will be picking those consumers where there are overlaps, okay? So I'm fixing the product market problem in principle. However, if the merger, and you have ignored it, also creates oligopsonistic market power, the merged entity will have, as I just said, a greater incentives exposed, no matter what's the level of competition downstream, to increase prices. So in a merger analysis, you do what we call a counterfactual. If you don't account, I don't know if it is empirically relevant, I don't know. But if it is empirically relevant that there is oligopsony, and this is not somehow built in some model of your counterfactual, you will be underestimating market power in your merger assessment. Okay? So that's important to acknowledge. That's not what we do at present. Which brings me to my last point, very quickly. I may elaborate on it later on. My own very personal, very private, very specific experience. I have only a limited experience, but of some significance with the EU, with DG Comp of 3 years. In my 3 years, I have done 0 cases that would involve labor markets. I have had zero practical discussions. I had abstract discussions because these papers were coming from the US on concentration in labor markets, and we have curiosity. We are still alive in intellectual, which is good. But when it comes to the application of those ideas, they went nowhere. So I have never met a single representative of the unions in my 3 years, okay, never. I have never received a reasonable submission, an economic submission that would mention labor market issues. Again, it's just my own experience. I don't want to make a general statement. It's just a personal. Labor unions typically are seen either during the oral hearings towards the end of a merger process, sometimes, not always, but at best they are seen when the merger is already decided and then a divestiture has already been decided, and then they are discussing the implementation of the divestiture. And that's where the unions get worried, because the divestiture sometimes may hide actually winding down a plant. So they are concerned that there may be job losses. Okay? But I've never seen an economic analysis examined prior to the merger, which is interesting, in my view, and we should do more. And there are two reasons, perhaps, for this. A good reason for not having seen cases and a bad reason for not having seen cases. The good reason is that, as it has been said, labor markets are local. So I would expect, perhaps rightly so, that DG Comp would not be doing those cases, because it should be more pertinent to the NCAs, to the national competition authorities. That's a good reason. The bad reason is what I said earlier instead, which is it's a catch-22. We don't run cases, we don't learn about it, we don't have precedents, there is no case law, hence we are not going to do, because we are really insecure about it. Okay? So, in fact, again, these are some mythical discussions I had with some colleagues, with consultants, with lawyers, said, oh, but if you ask the unions before a merger, they will always support it. Okay? They will always be in favor of concentration of market power. To me, this is a myth. Okay? I don't see why economically that would hold true, but it would be great to hear more from them, not just because they're important, because they may also help me as an economist to understand how important this is, taking a very strict view on the consumer welfare standard. I'm not doing anything which is bizarre in that sense. Thank you very much.
Thank you, Tommaso. So already from this discussion, I have quite a number of questions, but I wanted first to ask you whether you want to react to what you heard, of course.
So I wanted to answer your last point. As someone, an IO economist who has worked in labor markets 35 years ago, and that was looking at the incidence of rent sharing in regulated industries. I think that part of the reason sometimes that labor unions may not oppose increases in concentration is because workers often, at least historically, I haven't looked at this as much lately, but shared in rents. So it's a little odd to say that if you're worried about workers, you should make sure product markets are super competitive, because if product markets are super competitive, there are no rents to share. So there is a bit of a catch-22. But I would say we did hear from unions, not infrequently, although there I think it was much more directly about concern about, say, plant closures or layoffs, and not so much even then about wage effects.
So maybe we'll have an opportunity to discuss this with the Trade Unions Advisory Committee in a bit. But first I wanted to ask you on your initial remarks, Nancy, for those jurisdictions that use the consumer welfare standard as their standard in its current interpretation, is it flexible enough to accommodate the analysis of labor market harm, meaning anti-competitive harm occurring in the upstream labor market only without negative effects on consumers?
So I'd answer that in two parts. So first, as Tommaso's pointed out, if it's a classical monopsony problem where the harm is being exercised by withholding purchases of inputs, that will have a downstream harm. And so even if all you're worried about is downstream consumers, I think you can bring that under a consumer welfare standard in a very straightforward way. I think a more challenging case is where it might be due to bargaining leverage. So you're not withholding purchases, but you're able, through reduced competition among the, say, merging parties, to push down the bargain that the upstream workers or union or upstream supplier is able to extract. So that's the first thing. And then I think I've grown to appreciate that while many of us say we have a consumer welfare standard, there's a consumer welfare standard and there's a consumer welfare standard. And I think in the US, the right way to think about the consumer welfare standard, and I'll quote Doug Melamed, who explains it as a trading partner welfare standard. The US has a rich history of case law that basically says if there's some anti-competitive behavior, including a merger that adversely affects a trading partner, whether that trading partner is someone you're selling your product to, or it's somebody you're buying an input from, labor, farmers, input suppliers. If that harm is coming about because of a reduction in competition, it's actionable under the antitrust laws. So Scott Hemphill and I have an article where we describe both the economic and legal underpinnings for that in the United States, and I think that it's fairly straightforward. There are precedents, certainly in terms of litigated cases. Most of those are in the conduct realm, so things like predatory pricing or buyer cartels or buyer collusion, but where the courts have held that you don't have to show a downstream harm to have it be actionable. The one merger case in which this was raised was at the very end of my time at the Department of Justice, which was a health insurance merger between Anthem and Cigna. And the department alleged both downstream harm in terms of higher prices for insurance to employers and other purchasers of insurance, and upstream harm in terms of reduced payments to healthcare providers, hospitals, doctors. I don't think we got into nurses, so we didn't get into the nitty-gritty of labor, but certainly thinking about doctors as providers. And while the district court judge preferred not to get into that upstream harm determination because she found there was plenty of downstream harm to block the merger. The companies appealed her decision to block the merger, and the appellate court held for the Department of Justice and moreover said that you couldn't claim upstream price reductions in what you paid for health care as an efficiency downstream if it was the fruit of the poisonous tree. So if you were getting those reductions because of a reduction in competition or anti-competitive actions, you couldn't then flow them downstream to a benefit. So I think even under something like the EC final consumer welfare standard, you might not be able to go after something, I'll leave it to EC lawyers to tell me more about it, if it were only in the labor market, but at minimum, you should be able to not recognize those upstream reductions in wages as a benefit for consumers downstream because they're flowing from anti-competitive behavior.
Yeah, that's clear. Tommaso, would you like to give the EU perspective on this?
I will give you my perspective. So, I agree with Nancy in theory that we have, in Europe also, a welfare standard which is flexible enough. So, if you interpret it as a multidimensional thing, it's about prices, it's about choice, it's about innovation. It could also, as I said, have this effects via labor market. So I think the tools are out there, in theory. But then I see a reluctance, rather than from the enforcers, but from the legal community, anytime you try to venture outside the pure static price effects. The Commission will try to do, remember the infamous Dow DuPont to do something on innovation, and the infamous Google Shopping to do something about consumer choice. Anytime you try to put in practice this multidimensionality, people jump on you and they fight, and then people get scared. Okay? So in the end, enforcers are cornered to do the usual static price effects in final markets, which is a very partial view of the consumer standard, okay, of consumer welfare. So if the system obliges enforcers to stay there, it is a very, very imperfect system, which could be supplanted by anything else, as far as I'm concerned, because it's not even second best. I have no idea what it is. Okay? It's missing so many aspects that it could be something else. Let's focus on well-being, on something else, and that's so there is no reason for sticking to that, just because we have enough experience with prices, static prices. So what I'm saying is that in theory, I would love to agree with Nancy. In practice, I do see lots of reluctance and resistance, rather than from enforced, to be honest, but it's from the legal community, which is extremely conservative. Extremely conservative for reasons that you might expect. They're sitting on rents. They're working for people who are enjoying big rents, and they want to preserve the status quo. And this status quo serves them fine. Okay? I'm not sure the status quo is an optimal situation.
Thank you very much. Eric, I wanted to ask you, suppose that you had to advise a competition authority or a company that is new to this kind of issues, and what type of cases are the most likely to emerge and should be prioritized by agency when they're scanning markets looking for labor market harm, for instance, because they're easy to prove?
Clearly, I think there's going to be increasing merger review involving an examination of labor market effects. But I think the next controversy, the next focus of enforcement will involve covenants not to compete. And as others have mentioned, recent research has suggested that in the United States and apparently in Europe as well, non-competes are extremely common. And while they're historically reviewed under these sort of limited non-competition law standards, it seems very likely that approach has been inadequate. Just reflecting a bit on Nancy's comments, I'm not sure Nancy and I really disagree that much about the facts and the law, but what I think where we differ is I think what we're seeing is a big thing, not a small or medium-sized thing. And I'm reminded of, Adam Smith said, it's much easier for firms to make money by colluding than by innovating. And he himself pointed out that one way to collude, of course, is on the product market side, but the other way is on the labor market side. Now, if there's been a fair amount of product market enforcement over the last century and very, very little labor market enforcement, and if you believe that firms are run by rational profit maximizers, then you would have expected them to have figured out various ways to reorient their anti-competitive behavior from product markets to labor markets. Now, in the United States in the past, the major response to anti-competitive behavior in labor markets was labor organizations. In the United States, union density peaked in the 1950s and has declined steadily ever since. And I was speaking to a lawyer for a union recently, and he pointed out that if you look at collective bargaining agreements, which are, of course, public, you would never see a covenant not to compete, never. It would not even be something that the employer would propose. And even though not all American workers were members of unions, the collective bargaining agreements tended to sort of set the terms, even for non-unionized firms. So I don't think it's a coincidence that with the decline of union density, you see a rise of covenants not to compete. Firms, probably advised by their lawyers, have discovered that this is a useful way to increase their power over labor markets. If non-competes are as common as people say, then the concentration numbers understate the problem. Because even if you have 10 employers, if they all have non-competes, effectively there's one employer in that market. I think, now the thing is that, and this is the last point, is that nobody really knows about, which companies have non-competes, except occasionally there's a scandal. The data that was referred to before, these are based on surveys, and the respondents are anonymous. So as this information comes out, I think there will be a lot of enforcement. So my advice for the employers is to stop using them. They clearly use them, by the way, in a kind of not in the kind of customized way that you're supposed to when you negotiate with a worker with specialized skills or access to trade secrets. They're simply added to mass employment contracts that are imposed on thousands of workers who never read the contracts and don't know about the non-competes until they tell their boss that they want to leave. So I think there's that sort of stuff is going on, and more stuff that is going on that we're not aware of, and that will eventually receive the attention of competition authorities.
Thank you. Now, Andrea, moving a little bit to this idea that also regulation can play a role, I wanted to ask you what other tools are there and what is their relationship with competition enforcement that may be effective in counteracting the negative effects of monopsony power, and in particular, are collective bargaining exemption a good way to build this countervailing buyer power against monopsony?
Okay. I think this opens kind of what we are obviously interested in, because the idea is that there are a number of different possible instruments, and there are the instruments that are under competition policies that, as you said also, that it not necessarily, I mean, you have objectives and not necessarily they are the same objectives, so it's useful to use different type of instruments. The other issue that, and then goes to the issue of collective bargaining, is that in general, I mean, all the discussion we had was about essentially the possibility of identifying a violation of competition policy. Even when we talk about, for example, non-competes, the issue is whether this we can make a case on the specific case that it violates its use for anti-competitive purposes. Of course, to do it on a large scale, because of the need of information involved, this requires massive intervention from enforcement authorities, and typically either we endow these authorities with a huge amount of resources, or otherwise it becomes kind of difficult on a large scale. So from that point of view, regulation on the one hand and other instruments which allows other parties to better bargain could be essential. Now, one of the first things to note in that, and I go to the collective bargaining could be one of the issues, and to the extent that at least it can create a countervailing seller power, and so if we manage to create a bilateral bargaining, this could improve efficiency. Now, the issue is that this concern employees, but typically it doesn't concern independent contractors. Now, if I go back to what I said at the beginning, the very few studies that we have on the residual labor supply elasticities for independent contractors, and there are very few, that's for sure, but there are the few of them that exist, they are published on very, very good journals, so in a sense it's an indicator also of quality independently. They are extremely low residual labor supply elasticity. So essentially, let's say those independent contractors that are in fact in between, a situation between dependent and self-employment, they find themselves in a situation where they have a number of characteristics similar to employees, but in fact they are even more deprived of a number of rights, in particular the rights of collective bargaining. And this is in particular because whenever there is ambiguity, courts typically, when there are the factors that compose the test that you use to identify if somebody is an employee or an independent contractor, typically courts, when there is ambiguity, decide that the worker, because it's a question that is asked to them, is not an employee, and so in a dual world, that's become that the worker is an independent contractor and doesn't have the protections that are including the access to collective bargaining. So, of course, this is not as simple as it could be, because the difficulty is to, in a sense, design possible solutions, regulatory solutions as well, that do not interfere with competition law, so it doesn't make competition policy inefficient. And in that, we have at the OECD conducting research on this, on possible avenues. There are countries that extend collective bargaining access through derogations, and there are countries that do this extension through labor law. And I personally consider that the labor law route is simpler and less dangerous, because when you do it in terms of derogation, then any derogation creates the demand for itself. And then that means that you ask at the end also competition authorities to examine each derogation and to identify whether it's possible to grant or not this derogation, while the labor law routes essentially means to define what is this intermediate category between a self-employed or therefore an undertaking and a worker which is simply selling labor with respect to a unique customer in that sense. And that is possible to do it, and there are different examples, including, although not applied to collective bargaining, recent reforms that have been taken in the United States, and particularly in California, that seems to go in that direction.
Thank you very much. One last quick question to Tommaso. In the case of merger controls, what kind of remedies should be considered acceptable by competition authorities and appropriate? Do you agree with Nancy that we need to be careful with divestitures?
Well, divestiture, unfortunately, is one of those are boxes that we don't open often enough. So we typically use a lot of divestitures in mergers, and then we very rarely check how those divestitures work out. So it's difficult to come up with a view if we don't know whether those divestitures are effective or not. For sure, with time, we learned that we have done strange, esoteric carving outs that we try to avoid, to say the least. But in terms of remedies, the first thing is to identify what is the problem that you have. And as I said, currently the system is not really geared to finding an association between, at least in the EU, market power in labor markets and market power in finite markets. So if you don't see the connect, you're not ever gonna fix the problem. So I think the message here is to try to reduce this distance between theory and practice. In theory, we heard we have lots of models available. In practice, we have to start using them, so we learn about them. So my call is for authorities and to see whether empirically these things are relevant or not. Maybe there is no market power in labor markets in your own country, in your own industry that you're looking at. So I would doubt that is the case if I listen to my labor economist colleagues. But anyway, do that. Embed those characteristics in the merger simulation models, and then you see where the problem is coming, and then you will find an appropriate remedy.
Thank you very much. So I'm conscious of time. Very interesting debate so far, but I would like to give the audience an opportunity to ask questions. So I know that TUAC, as I was saying, the Trade Union Advisory Committee would like to make an intervention. They act as representatives of organized labor here at the OECD. Do you have a microphone? Okay, maybe time for another question in the meantime. Okay. So.
Hello, shall I stand up? The question is this. As a practitioner, maybe I'm a bit short-sighted on things, but I was trying to imagine, like in a merger assessment, how the labor market could be accounted for in practice. So imagine I have a merger, right, between producers of wooden toys, and you have the Form CO that is filed, and the parties have to decide what to write in the efficiency section. Can they say that as a result of the merger, they will be able to negotiate lower price for the wood, and that is going to be a variable cost reduction, and therefore is going to be passed on to consumers, and therefore is going to be a countervailing effect? Now the question is, if the answer to this question is yes, then can they do the same and claim the same type of argument for a reduction of competition in the upstream market for labor instead of wood? And if the answer is no, then I wonder whether this is due to a certain distinction that needs to be made. That is, and I wonder whether that is possible really within the framework of the consumer standard, or we need to elaborate a new standard, to which I'm personally pretty much sympathetic. Thanks.
So I'll jump in and say, if the parties are arguing that because they'll have, they used to compete against each other in the market for wood, and now they don't, so they can get lower prices, I believe my former agency, the DOJ, would call that a competitive harm. Thank you very much for helping us to prove that part of the case, and we'll also look at whether there's downstream harm. And the same analogy then would flow through to labor. So I think sometimes companies will argue upstream price reductions because of resource savings. You know, we're now buying our wood in larger volume. It costs people less to deliver it to us. Therefore, the price is down. Those are true efficiencies. We'll pass them on to consumers. Those are benefits. Maybe they'll offset the upward pricing pressure, and the merger will go through. But if it's an anti-competitive effect, so if it's because of either a monopsony type of story where they're going to purchase a little less wood, but that's going to drive the price that they pay for the wood down, or if it's a reduction in competition, bargaining leverage. Scott Hempel and I argue that, and case law in the U.S. is consistent with, that's another harm of the merger. And the same would go through. You treat, in either case, treat labor symmetrically, we would argue, to any other type of input.
So in the Form CO, you have to do a better job in explaining the mechanism. So it's not just prices will be cheaper. That's not enough, because you're not telling what the mechanism underlying the price reduction is. So if there are economies of scale, in the wood example, let's say perhaps quantity discount, economies of scale in labor, okay, good luck. Okay, good luck. So, but more specifically, if the wage reduction comes from withholding, from employing less people, okay, which is truly at the root of monopsony power, this, as I said earlier, will also lead to a consumer detriment. So this is not going to fly well at all.
Thank you very much. Apologies to Chuak for making you wait. Please come to the podium for your intervention. You're very welcome to come. Excuse me.
Thank you. Thank you very much. I've been treated, I enjoy this special treatment. I'll be short because I realize that time is running out. To bring precisely a point of view from the trade union, a stakeholder which has been mentioned a couple of times here, we are naturally very happy to have the OECD discuss labor market monopsony and the potential future role that competition regulators would have. Briefly, one point that we'd like to bring to the panelists, and I don't know if we have time for a reaction, and that's about the future of the OECD in that domain. Because historically, from the trading point of view, we know how to deal with labor market monopsony. We know how to deal if we have the tools with them. And as some of you mentioned, collective agreement, the coverage of collective agreements has been falling down. It's fairly dramatic way in some countries, like in the US, union density. In Europe, in some countries, we still have a fairly good coverage, but it has been emptying from inside in terms of substance, in terms of true protection. And what we often say within the labor movement is that actually the collective bargaining house is burning, and many of you are actually looking in the other direction, so to speak. And the question is, some of you have alluded to it, which is that we have, on the one hand, corporate concentration, and it so happened that at the same time we have a severe, dramatic loss of bargaining power from workers. So in 30 years ago, 40 years ago, I think we would have been able to deal with the consequences of labor market monopsony, because indeed, if you're in a collective agreement, you can address anti-competitive clauses. Especially if you have a sector-wide collective agreement, you can deal with those anti-competitive practices. But today, with the individualization of labor market, the fall of collective bargaining, the fall of union density, and the disruptive nature of digitalization, which creates gray zones, as Andrea mentioned, independent contractors who economically are employees, but also with new businesses that are outright anti-union. Most of the CEOs in the digital sectors are anti-union. They say, we don't want collective bargaining, it's not part of our own culture. So from there, what would be the role for the OECD? There is a very good a publication coming out on competition today. Just 2 months ago, there was also a fairly interesting publication by the OECD, Negotiating Our Way Up, making the case for promoting collective bargaining. So what would be your advice? I mean, you are surrounded by 2 OECD experts, but to the speakers, what would be the advice for the OECD? Should the OECD continue with a fairly robust but still silo approach, competition experts on one hand, labor market specialists on the other? Or should we try to deepen a bit a more integrated approach? Indeed, at the surface, we have those anti-competitive practices that needs to be dealt with, but perhaps below, there is a severe problem of bargaining power of that constituency called workers. So how can we move toward this a more integrated approach, and how can competition regulators better account for the labor aspects? Thank you. Thank you very much.
Thank you very much. Anyone wants to comment on this? Eric?
I can only speak from the perspective of the United States, so using that as my parochial basis. In the United States, there's a great deal of hostility against unions at sort of the national political level and in many states, and that, along with changes in the economy, has drastically weakened unions. But at the same time, I think in the U.S. there's a great deal of prestige for competition law and the agencies that enforce competition law. Now, I don't know whether the decline in union density can be reversed. You know, people argue about that, have been arguing for remedies for a long time without any effect. I do believe, though, that as a practical political matter, it is possible to orient competition law to labor markets in a way that would partially make up for the decline in union density. And interestingly, in the United States, we have, I don't believe you have this in Europe, or not as much, but we have the class action mechanism. And you can think of a class action as a bit like a very temporary union. The workers are brought together not by union organizers, but by lawyers who aggregate their bargaining power for the purpose of a lawsuit against wage suppression resulting from anti-competitive practices. That I can see happening with increasing frequency in the United States, and also, to some extent, increasing government enforcement. I don't know how to bring those insights over to Europe, but to the extent they're helpful, that's what I can offer.
So, Eric, could I ask you a question about that? Because I had always understood the decline of labor sort of countervailing power in the U.S. and the decline of protections is in part linked with the decline of unionization, but it's much, much broader. And one of the things that's quite striking, even more common than non-competes, is the rise of arbitration, mandatory arbitration clauses in labor agreements. And so, and I think there are court cases that have ruled that if you're under one of these mandatory arbitration clauses, which you, again, probably didn't even know that you agreed to when you came to work for that company, you can't engage, or at least it's much, much more difficult to engage in a class action lawsuit. And so I think that has also contributed further. So I don't know if there are similar erosions of labor protection that aren't specific to unions in Europe and other economies. What's interesting is, you know, given the rise of populism and how unhappy so many people are with the state of the economy, that somehow there isn't more pressure to reverse some of this. Maybe it's coming, but you know, I think some combination of changes in labor protection and regulation along with competition policy would be the most effective way to make real progress on this. So going after some of these egregious behaviors that Eric and others have talked about, like the non-competes or the no-poaches, but then also finding ways to build in more worker protection.
Okay, thank you very much. It's fine. Okay, thank you very much. It's been an extremely interesting discussion. Unfortunately, it is with much regret that I say that it is now time to conclude. So I'm going to give our speakers the opportunity to share with the audience one last key message that I would like to leave us with. But before I do so, there are like 3 main points that it seems to me it can be drawn from the discussion that I would like to highlight very quickly. So with no ambition of completeness. But one, there are some diverging views on the pervasiveness of monopsony power in labor markets and on how the evidence should be interpreted. But there seems to be consensus among the speakers on the fact that competition authorities have not devoted enough attention so far to labor markets and may have overlooked important anti-competitive effects on workers and consumers. Two, although some adaptations of the current enforcement tool, of the current enforcement framework and of the tools that are available may be required for competition authorities to be able to fully address employers' monopsony issues, there is space for competition enforcement in labor markets, and this will necessarily have an impact on the way in which companies behave and might have to be taken into account more seriously in the design of their compliance programs. And 3, regulation may be a suitable way to address some of the issues and may well be seen as a complementary to competition enforcement. In those cases where regulation is appropriate, competition authorities may be called to contribute their unique expertise on the analysis of monopsony power to better target regulation in a way that minimizes competition distortions. And in those cases, the role that trade unions will have will be fundamental. So this is it from me. I would like now to give you 1 minute, 30 seconds, even better, to convey to this audience your main takeaways regarding this topic, and I would like to start from Andrea.
Okay, so I take up on the point on regulation, just to try to put it in a different perspective. My understanding is that much of what we have discussed today was about enforcement, and enforcement means each case taken one by one. So in a sense to be very precise and not to make errors in what we analyze. This gives a limitation of our power. The approach, at least from the labor side, to regulation is that sometimes when we have some good understanding on certain situation, we may use regulation to, for example, prevent them, even if in these cases, in a limited amount of cases, we are not doing the most efficient thing. Because if you divide the things that are prevented by certain regulation, in certain specific cases, this would have been efficient. So, for example, in the case of non-competes, again, it could be very desirable to decide what are the markets, for example, that the type of workers where there is a good presumption that they are used in an abusive way, even if there might be some very specific cases in which they are totally legitimate. And I stop here.
So I would have just 2 quick things to leave you with. One is, I think competition policy enforcement is inherently precedential and small c conservative. So we get to where we want to be by starting small, picking a really clean labor market case that we can bring. I hope the Department of Justice has been straight with us when they said since the new administration came in, they've got a criminal labor market case on deck. We're just waiting to see it, but that would be great to bring a really strong case and get a conviction, because like regulation, that will have a very strong deterrent effect and probably, eliminate a lot of bad behavior once the first executive goes to jail for that. So I would just encourage those of us who are still in competition enforcement or speaking with them, not on behalf of any clients or anyone else, as I am also only employed by the MIT Economics Department, but to help sort of advance this incrementally.
So I have a wish, actually. So a year from now, when you will have another competition day, I hope there's going to be a panel on this topic without us, without academics, but with regulators, with national regulators, that instead of saying, as we said, in theory we understand the mechanism, but in practice we don't know, we will hear, in practice we run some cases, what have we learned from them? That's my wish for next year.
I should also mention that no one's paying me to say these things, although I'm hoping to bring a lawsuit. So if you have any ideas, I can do no better than repeat something that Tommaso said earlier. Let me put it in a slightly different way. You know, we have theory. Theory says quite clearly that employers should engage in anti-competitive behavior. We have an increasing amount of evidence which suggests that they are. And we have the law, and at least American law, and I believe European law, clearly would prohibit anti-competitive behavior that harms labor markets. But there's a last layer, which is practice. And there's an inherent inertia or conservatism, as Tommaso mentioned and Nancy just mentioned, that has to be overcome. That's the difficult part. And so people need to get out there. They need to make arguments. They need to urge their supervisors to take these problems seriously. And then once that happens, then then we'll see a lot more activity.
Okay, thank you very much. We are really at the end. I want to thank our amazing panel, Andrea, Nancy, Tommaso, and Eric. Thank you so much for being here. It was really a super interesting discussion. Hopefully we'll hear more and more about this topic. So please join me in thanking them.